Testing, one, two, three. Testing, testing, one, two, three. Test, test, test. Testing.
States Court of Appeals before the 7th Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention, as this court is now sitting. God save the United States and this honorable court. Please be seated.
Good morning, everyone. On behalf of the court and my colleagues, Judge Brennan and Judge Scudder, I'd like to first extend the court's thanks to the University of Wisconsin Law School for hosting our argument session this morning. We're very glad to be here. There are a few ground rules. I know you've been briefed on those ground rules. No photography, no recording. We are recording the arguments for the court's purposes, and we will make one exception to the no photography policy to permit our circuit executive to take a photograph of the bench for posterity and for your archives here at the law school. All right, with that out of the way, we can begin with our argument session this morning. Our first case for argument is Lamar Robinson versus Grace Knutson. Ms. Nicholas.
Good morning. May it please the court. Words have meanings. When the state brands an individual as a sex offender, that conveys to members of the public that that person has committed and been convicted of an offense involving sexual misconduct. Neither Lamar Robinson nor Martell Rogers has ever been charged with, let alone convicted, of an offense that involved sexual misconduct. Nonetheless, the state of Wisconsin has branded them both as sex offenders, and for the rest of their lives, they will be subject to the conditions that the state applies to people who have been convicted of sexual offenses, including a requirement to register, community notification when they change their addresses, and lifetime GPS monitoring. In dismissing the plaintiff's complaint, the district court found that it raises neither procedural nor substantive due process problems to label an individual as a sex offender who has never been convicted of an offense that required proof of sexual misconduct. That was an error. Turning first to the procedural due process claim, the district court found that the plaintiff's complaint was foreclosed by the United States Supreme Court's decision in Connecticut Department of Public Safety v. Doe. As we've pointed out in our briefing, Connecticut Department of Public Safety v. Doe is inapposite to this case for the simple reason that in Connecticut v. Doe, the plaintiffs, the people who were challenging the constitutionality of the registry, had indisputably been convicted of offenses that required the state to prove beyond a reasonable doubt that they had committed sexual misconduct. Here, in contrast, the plaintiffs have never had a procedurally protected opportunity to contest that they are sexual offenders as any normal person.
That's not what the statute prescribes for the registration requirement. There's no requirement of a sexually based offense in the case of your client's convictions for false imprisonment of a minor.
Correct. Under Wisconsin law, certain offenses that involve no sexual conduct or no sexual motive at all are defined as sexual offenses. And really the question here is whether it is enough to just call something a sex offense. Calling something a sex offense does not make it so. And the plaintiffs have never had...
That's an argument about the content of state law, not the absence of process.
So, okay. So the department's response to our point that you can't just define anything as a sex offense, right? This would enable the state to define DUI or speeding in a school zone as a sexual offense.
But again, that's an argument about the content of state law. It's a substantive argument. It's not an argument about the lack of process.
Yes. So the state says, okay, well, we couldn't do that because substantive due process would provide some kind of backstop against that. But I think that really dovetails with the substantive question here, because the state's argument is that, well, we can call anything a sex offense that endangers children, or if it may assist law enforcement.
I can ask the question in a different way to focus on the procedural due process argument that you're making. What would you want a hearing what would the purpose of a hearing be? What would the question at the hearing that you say you didn't get or your clients didn't get before being labeled a sex offender who must register?
To establish that the individual had a sexual motive for the offense.
But
or
that's not what the law provides. It's a categorical inclusion in the registration requirement. So
Right.
your argument really relates to the substance of the law. There's no process violation here.
So
They are subject to the requirement, the registration requirement, by virtue of their conviction for false imprisonment of a child. So to demand a hearing to prove something that the law does not require is really a pointless exercise. Your argument is all about substance.
it's an exceptionally broad reading of Connecticut versus Doe that the state is engaging in here.
What
Would
language do
enable,
you have in mind in that opinion? I got it right in front of me.
pardon?
What language from Connecticut Department of Public Safety do you have in mind? Because I don't see anything turning on the point you're making in the court's opinion.
Well, it didn't come up there because it was not disputed that the individuals had engaged in crimes involving a sexual component.
But you would think if the procedural due process, what kind of hung from was dependent upon, conditioned upon the substantive point that you're making, there'd be some indication of that in the court's opinion.
Well, in the court's opinion, they actually say they're saying that the procedural claim was foreclosed there because the individuals had already had a procedurally protected opportunity to contest whether they had committed the offense. And they had the full panoply of procedural protections in the criminal case, and that was enough to satisfy procedural.
Isn't that Chief Judge Sykes's point?
Yeah, so the Supreme Court did leave open this substantive claim, and I think we should turn to that because the state's argument here is that if an offense endangers children or if it might assist law enforcement to have individuals convicted of certain offenses on a sex offender registry, then it is consistent with substantive due process to label those individuals as sex offenders and require them to register. So I think the state's argument should be taken seriously, where they say there is some backstop in substantive due process against just willy-nilly labeling offenses as sex offenses requiring registration. So really the question of this case is, where is that line? Because there is one. It cannot just be that this is a dangerous crime or one where law enforcement may be assisted by having people on a registry.
Isn't that line drawn by the legislature in the law?
I think that the federal constitution and the due process clause is a backstop against these legislative overreaches. As we know, legislation like the Adam Walsh Act and the Jacob Wetterling Act are enacted in the wake of crimes that rightly arouse a lot of fear and passion and a desire for a strong response. So sometimes legislatures overreach when confronted with these kinds of very terrifying crimes that, of course, arouse strong passion. So that's why we have to have the courts look more closely at the fit between what the government is doing.
It's not a question of fit under rational basis review. That's only a heightened scrutiny question.
So I think there are real questions about whether some level of heightened scrutiny ought to apply here, because what is happening is not just registration, but a whole host of changes to a person's life, including a requirement of being monitored by GPS for the rest of their life.
That's something new, and that's introduced at the appellate level, so we're not going to address that.
Okay. Well,
This is just, they're on the registry. That's what this litigation is confined to. And so we're in rational basis review and not heightened scrutiny. So it's not a question of fit or over-inclusiveness or under-inclusiveness. It's just a rational basis for the law. So perhaps you could address what that issue actually is in the case. That's the substantive
so
point.
under substantive due process, the state, it has labeled certain offenses as sexual offenses requiring registration that don't involve any sexual conduct or sexual motive. The question is, why do we have sex offender registries? The state says for general public safety purposes, for general assisting law enforcement. That is too broad a formulation of why we have sex offender registries.
Actually, Congress made some very specific findings in adopting the Jacob Wetterling Act and then later the Adam Walsh Act about the connection between false imprisonment, child abduction, and child molestation and sex offenses against minors. And Congress in those laws mandated that states receiving federal funding bring their own laws into conformity with that national scheme. And so the congressional findings are highly relevant here to the rational basis for the law.
I think there are two issues with this statistical correlation as it was cited by Congress and adopted by the state in their argument here. The first one is that there are a lot of things that are statistically correlated with sexual offending, including being homeless, unemployed, or for that matter, a male under the age of 40. So the argument is an extremely broad one for what can be put on the registry if it just has some correlation or statistical correlation with sexual offending. But more importantly, there is a logical fallacy at play here. And this was discussed very clearly by the High Court of New York in the People v. Brown case, which we cited in our brief, which is they looked more closely at those studies and they said really it was an error to rely on them for the basis for putting these offenses on a sex offender registry, because those studies were of abductions that ended in sexual offending. Here, there is no question whatsoever that there was no sexual motive or sexual conduct involved in the burglaries that our clients committed.
On the rational basis point, it's difficult for me to see how the Wisconsin Supreme Court's decision in Smith from 2010 doesn't just foreclose the position. Not as a matter of like issue preclusion or something like that, but it's the state's highest court explaining what, in its view, is the rational basis for the registration requirement. Don't we have to pay attention to that?
Well, this court, of course, has jurisdiction to decide the federal constitutional question of whether this is consistent with due process.
Right, but the Wisconsin Supreme Court has described the purpose of state law, and they're the final say on state law.
So we call this a sex offender registry, and the question that was at issue in Smith and what the justices of the Wisconsin Supreme Court were disagreeing about is what is the purpose of a sex offender registry? Is it generally assisting law enforcement and promoting public safety, or is it to notify the public of sexual offenders? And I think where the Wisconsin Supreme Court went wrong in Smith is giving it this extremely broad formulation that if the law might assist law enforcement in some way, or if the offense poses a danger to children, then therefore it is rational to put those individuals on a sex offender registry.
Ms. Nicholas, do we know at the time that both of the plaintiffs here were sentenced felony convictions? There would have been a pre-sentence investigation report. Part of that PSR would have included the idea that they're going to be placed on the sex offender registry. Do we know whether there's anything in the sentencing hearing or at the trial court level that there was an objection to being placed on the offender registry as a result of this crime not having a sexual component?
That I don't know. I don't know what happened in the trial courts when they were convicted and sentenced. But there was really no need and no part of the proceedings in which the state ever alleged or had, let alone had to prove, that there was any sexual conduct or sexual motive to these crimes. So unless the court has other questions right now, I'll reserve the remainder of my time. Thank you.
Ms. Schmelzer.
Good morning, and may it please the court. I'm Jody Schmelzer, an Assistant Attorney General for the State of Wisconsin Department of Justice, and I represent the defendant appellee in this case, Grace Knutson, who is the Director of Sex Offender Programs for the Wisconsin Department of Corrections. In my argument, I'm going to first address how the district court correctly dismissed the plaintiff's substantive due process claim because Wisconsin statute and inclusion of the crimes of false imprisonment of a minor and child abduction as qualifying sex offenses survives rational basis scrutiny. Then I'll address that the district court correctly dismissed the plaintiff's procedural due process claim based on the Supreme Court's decision in Connecticut Department of Public Service v. Doe. The Wisconsin legislature acted rationally when it included the crimes of false imprisonment of a minor and child abduction as qualifying sex offenses for its sex offender registry. We know, and as the panel has already acknowledged, that there's an extensive congressional history for the federal acts that do the same thing. as well as the state Supreme Court's decision in State v. Smith that establish and acknowledge this nexus between including crimes like false imprisonment of a minor and child abduction in a sex offender registry. We know from the congressional record that there are over 114,000 non-family attempted child abductions a year, and 4,600 children like Jacob Weddingling disappear each year. We also know the nexus with sexual harm to children is that 2/3 of non-family child abductions reported to police every year do involve some form of sexual assault.
Ms. Schmelzer, how does the state know that someone has not been improperly placed on the register? When does that issue get joined? How does it get joined?
What happens is when, and I'm not sure that this is in my brief, but there's a review of anyone who has some type of sexual offense as it's defined by this Wisconsin law prior to or when they're enter the DOC system. And there is basically like a review of that. And if it qualifies under the definition of sex offense, which is this law that plaintiffs are challenging, they are included in the registry at that time.
Does the offender have any recourse? Is that within the administrative DOC or is that done by the trial court, sentencing court?
And I think this gets into the procedural due process claim, Your Honor. It's a categorical inclusion for purposes of the sex offender registry. If they are convicted of enumerated offenses that are defined as sex offenses, including false imprisonment of a minor or child abduction, then they are going to have to register. The length of that registration depends on the nature of the offense and the number of those offenses. But they will have to register with the Wisconsin Sex Offender Registry Program. And it is because of that categorical approach that there's no procedural due process claim here, that the district court properly dismissed that claim. Because what the Supreme Court tells us in the Connecticut v. Doe case is that there's no other hearing that can take place that would change their qualification or their requirement to register. It's statutory, and any further facts that could be generated, even whether it was motivated by a sexual intent, is not going to be relevant for purposes of their placement on the registry if they were convicted of false imprisonment of a minor or child abduction. So it would be, in the words of the Supreme Court, a bootless exercise. This court has repeatedly applied the Connecticut case to these kinds of challenges to inclusion on a sex offender registry in both the Murphy v. Rutkowski case and more recently, the Kitterman case. It also applied it to a sex offender's challenge to residency requirements or restrictions for sex offenders in Illinois in the Vasquez v. Fox case. And there have been other circuits that have recognized that when that procedural due process challenges to sex offender registry requirements that mandate registration based on the conviction alone, those challenges are foreclosed by the Connecticut case. That was the Sixth Circuit in Doe v. Michigan Department of State Police.
The substantive due process challenge might shake out a little bit differently with the GPS monitoring requirement that was just adopted by the state legislature. I know that's not in the case because it's brand new, and there might be some justiciability questions with respect to these two plaintiffs, but that's a different level of burden on offenders in this particular category, offenders who were convicted of non-sex related child abduction or false imprisonment of a minor.
And I think I addressed that in my Rule 26J letter response, but I really disagree that there would be a heightened, that the new law would affect in any way the substantive due process claim here or the level of scrutiny that's applicable. The Supreme Court has firmly established that when a constitutional claim is covered by a more specific constitutional provision, you analyze that claim under that that level of scrutiny that's applicable to that claim. Here, a Fourth Amendment claim. And the Supreme Court has said that GPS monitoring does implicate the Fourth Amendment. We don't dispute that. But we don't believe that that heightens the scrutiny level for a substantive due process claim at all. You can't elevate a scrutiny level for substantive due process claims by asserting a new claim under the Fourth Amendment. It's basically an end around by attaching it to and creating some kind of hybrid substantive due process claim.
Understood, but the reasonableness inquiry under the Fourth Amendment might shake out a little bit differently than rational basis review under a substantive due process claim, because rational basis review is such a low standard, not a high bar for the state to meet. Reasonableness review under Fourth Amendment is a little bit different.
I would agree with that. And that issue is actually teed up in a class action lawsuit challenging the requirements of lifetime GPS monitoring under the Fourth Amendment.
So we'll see you about 6 months from now.
That's correct. And the court has already seen that case at the preliminary injunction stage. So yeah, we'll be back on that issue sometime later. But it's not proper to elevate the scrutiny level or to impact the substantive due process analysis at all in this case. And we do know, as I was noting before, that nexus between including these crimes on the sex offender registry and the purpose and the state interest here, which is to protect the public and assist law enforcement, but more specifically, children. We have that the great majority of cases where someone takes a child that doesn't belong to them is going to result in some kind of sexual violence being committed on that child. And as the court in State v. Smith recognized, requiring that proof of sexual motive for false imprisonment or child abduction would create a second layer of proof before placing someone on a registry, which would thwart the purposes of the registry, which is to give law enforcement a very quick access to people who have taken children in the past. And that's an important interest. There just isn't proof sometimes of those motives. And the Congress recognizes very clearly in its congressional history for the federal acts where sexual assault is thwarted before a child is assaulted, or where a child is never found, or where a child can't communicate about what the crime, or unfortunately where a body is too decomposed to ever show any evidence of a sexual assault. So that the Supreme Court in Wisconsin and Congress has recognized that those sorts of situations make it an administrative burden to try and require proof of sexual motive to include these crimes where there is a strong nexus that some sexual harm is going to come to a child if they're committed. I think my opponent's reference to a more narrowly tailored law is really outside of the requirements for rational basis review. And this court has held that rational basis review does tolerate over-inclusiveness, some over-inclusiveness. Again, we do have that nexus between these crimes and harm to children, violent harm to children, and sexual assaults. But there certainly does not have to be a narrowly tailored or a better law out there that's moving the level of scrutiny closer to the strict scrutiny analysis, which is not applicable here. I would also note that it is evident in plaintiff's argument that, moving on to the procedural due process claim, that what the real crux of their complaint is the substantive law, that the stigma plus theory that they use to support their procedural due process claim really only addresses the first prong of a procedural due process analysis, which is creation of a protected right of some way. The court in Connecticut v. Doe assumed that for purposes of its analysis, and then went on to say, as I noted before, that no additional process could reveal any facts relevant to whether or not those individuals would be placed on the registry because of the statutory requirement given their conviction. I would also note that the Connecticut case is is not as distinguishable as plaintiffs would like you to believe. That case involved a certified class of offenders that were deemed not dangerous sexual offenders. And Connecticut's registry law was similar to Wisconsin's, where it included the crimes of false imprisonment of a minor and child abduction without proof of sexual motive. Like 41 other states, they had a similar law to Wisconsin's. So it's certainly plausible and likely that there are individuals like the plaintiffs here that were included in that class and that were part of the Connecticut v. Doe case that were not deemed sexually dangerous and challenged that law. So it's not as distinguishable, although the named plaintiff was convicted of a qualifying sex offense that did involve sexual motive, that there were other members of that class that were similar to the plaintiffs here. Unless the court has any further questions, I will conclude by requesting that the district court decision dismissing this action be affirmed. Thank you.
Thank you. Ms. Nicholas.
Thank you. Congress did recognize a statistical correlation between abductions of children and sexual harm to children. And in a case where someone abducts a child and then sexually assaults them or attempts to sexually assault the child, there's of course that correlation there. And it's of course important to put that person on a sex offender registry, or permissible at least to put a person on a sex offender registry. But it does not follow that someone who falsely imprisons a child for the purpose of committing a burglary, stealing electronics and money from a home where there is no sexual motive and no sexual conduct, then should be presumed to present a future ongoing heightened risk of sexual offending against a child that would justify placement of that person on a sex offender registry.
Ms. Nicholas, playing your argument down the board, if there was a determination that in fact the crimes had no sexual component, what would happen next? Under what authority would the district court have to order that the person not register?
The federal district court could simply enjoin registration as to individuals such as Mr. Robinson and Mr. Rogers.
Would that be limited just to these two plaintiffs?
So I think that's a fair question. In this case, we have both a facial and as applied challenge. So we have a facial challenge to the idea of automatically counting cases that do not require proof of sexual conduct or sexual motive as sexual offenses, but it's also unconstitutional as applied to someone where there is no dispute that there was no sexual motive or sexual conduct, as there was for these two individuals. One thing that I think is
what would be doing the work in that portion of your argument, correct me if I'm wrong, in response to Judge Brennan, is you'd simply say it fails rational basis review. We reject the contention that strict scrutiny doesn't apply. You'd say it's irrational.
correct.
And therefore violative of substantive due process.
Correct. I think that something that counsel said regarding the stigma plus test, I think should be noted when we're looking at the substantive claim here, which is that it is undoubtedly stigmatizing to call someone a sex offender. This court has recognized that in the Shepers versus Indiana Department of Corrections case. And any person knows that this is one of the most stigmatizing labels that we can apply to a person. Now, of course, it's stigmatizing even if you have been convicted of a sexual offense to then be called a sexual offender. But if you have never committed a crime that involves sexual conduct in any way, it is stigmatizing to call you a sex offender in a way it simply was not in Connecticut versus Doe or any of the other cases where these types of restrictions have been upheld. Thank you.
Thank you very much. Our thanks to both counsel. The case is taken under advisement. And we'll move to our second case this morning. Dale Peshek versus Karen Timberlake, although I think we've had a change in caption while the appeal has been pending. It should be Brian Threlkeld versus Kirsten Johnson is the current Secretary of Health Services. Ms. Nicholas, welcome back.
He's a little afraid of you. Morning again. May it please the court. The Supreme Court explained in Sprint Communications, Inc. v. Jacob, that in the main, federal courts are obligated to decide cases that fall within the scope of federal jurisdiction. Younger abstention is a narrow exception to that general rule that only applies in 3 exceptional circumstances. 1, where a federal plaintiff is seeking to enjoin an ongoing state criminal prosecution. 2, where the federal plaintiff is seeking to interfere in ongoing civil proceedings that are akin to a criminal prosecution. And 3, where there are state civil proceedings that are uniquely implicating the state's judicial functions. None of those circumstances are present in this case, and therefore the district court erred in applying the Younger abstention doctrine to refrain from deciding the constitutionality of the housing rules that apply to individuals who've been released from civil commitment onto supervised release.
We've already held that Younger abstention applies to Chapter 980 proceedings.
Yeah, so I'd like to talk about that case and how it arose in very different circumstances than the case you have in front of you today. So in the Sweeney versus Bartow case, the plaintiff came to court and said it was unconstitutional to proceed with seeking to civilly commit him because the law had changed and he thought it was ex post facto as to him. This court, I think, rightly held that those proceedings were underway in the state court. He had the opportunity to raise any constitutional issues with those proceedings, and it wasn't proper, as a matter of comedy, for the federal courts to interfere with or enjoin those proceedings. I think that is a straightforward and proper application of the Younger abstention doctrine. This case is very different. I think it's important to think about what's actually happening in state court at this time. Mr. Threckheld's commitment proceedings terminated in 2009. He was committed 15 years ago. There are also no supervised release proceedings ongoing at this time. The state has stipulated that Mr. Threckeld meets the criteria for supervised release. So what is actually happening in state court? Once every 30 days, the DHS and the Kenosha Commission is coming back to court to report to the judge that they're not able to comply with his order that they identify housing for Mr. Threckeld. And what is the state court doing? He's repeatedly ordering the state to find housing for him.
So, Ms. Nicholas, is the argument that the supervised release component of the Chapter 980 statute differs so markedly from the civil commitment portion that that affects the abstention analysis?
I think we can even state it more narrowly than that, Your Honor, which is that there is no ongoing proceeding in which we are asking this court to interfere. The proceedings are over. The supervised release proceeding is not ongoing. All that is happening is they are coming back to court to find out whether they can comply with finding Mr. Threckeld housing.
Actually, there is an ongoing Chapter 980 case in Kenosha County, and there was activity in that case as recently as a week or two ago in connection with the petition for discharge, as I understand it, or at least that's what CCAP reflects.
Yes, I
can't go behind that and see what's actually going on, but there are reports being filed. There's an active monitoring of his supervised release status as well as a discharge petition. And this litigation in federal court seeks to supersede that and order the secretary not to enforce the housing requirements for his supervised release and release him immediately. How is that not an interference with the Chapter 980 proceeding that's ongoing?
So I want to address exactly what is happening in the state court, which is Mr. Threckheld's discharge petition was denied, and all that is being filed now is just paperwork memorializing that. The most recent action that's happening in state court is that Mr. Threckheld's public defender is asking for a motion to compel the state, the DHS, and the county commission to find housing for Mr. Threckeld because he remains now 4 years later eligible for supervised release as soon as housing is identified. And DHS, because of these housing rules that we're challenging in this case, simply is not able to comply with the judge's order. So the Younger abstention doctrine is concerned with federal interference in state proceedings. We are not asking for any interference. In fact, if the housing rules were enjoined, the state and the DHS would finally be able to comply with the judge's orders. Even the representatives of the county have come to court and said there is a fundamental flaw in this law. These restrictions are not possible to comply with. So what ends up happening, I think, is notable because it happened to two of the other plaintiffs in this case, Mr. Tran and Mr. Peshek, which is individuals are granted supervised release on the idea that they should have some period of supervised reintegration into the community after having been civilly committed. The state then spends years trying in vain to identify housing at which the person can reside while on supervised release. And eventually, 4 years later, after the person has stayed in custody for an additional 4 years without any ability to get any new treatment or make any progress, everyone gives up and the person is discharged. When they are discharged, Mr. Peshek was homeless. He registered as homeless. He had no period of supervised reintegration. Mr. Tran, no period of supervised reintegration. So
we can perhaps agree that this is a really bad policy outcome and it's a really bad practical outcome, but regarding the younger abstention issue, there is an ongoing Chapter 980 proceeding. It is open, and the litigation over his housing options continues, as well as the other reporting requirements that the state has and monitoring requirements that the state has for any Chapter 980 a committee, as Mr. Threlkeld is here. His attorney in that proceeding can raise the same constitutional arguments that you're raising here at any time, objecting to the housing rules in the same manner that you're objecting to them here in this federal litigation. So there's a complete and meaningful opportunity to challenge the constitutionality of the housing regulations, the 1,500-foot requirement as applied to offenders who must return to a home county that's populous, as Kenosha County is, as opposed to Vilas County, which is not. And so there is an argument of a constitutional nature to be raised here. That's what you're arguing in this litigation. That's a claim that can be made in the context of the Chapter 980 proceeding and addressed to the state judge.
Unfortunately, Your Honor, that's not quite right, because the state courts have held that you are barred from challenging the constitutionality of these housing rules unless you raised them at the time of your initial commitment proceedings. Now, Mr. Threlkeld was committed 15 years ago. He had
Nicholas,
no...
let me give you a hypothetical. Suppose there are two individuals that are authorized for supervised release, and hypothetically, the state court judge says, we're going to release you because you're Black. The second individual is not going to be released because he's white. You're saying you cannot argue that there's an equal protection violation? If determinations about placement on supervised release are flagrantly unconstitutional, you can't raise that in state court?
Well, I don't know what the state court would do with that claim. Of course,
Well, no, your point earlier was that state law required you to lodge your objections kind of ex ante up front. But an individual like this in a crazy hypothetical like I just gave you would say, well, I couldn't raise my objections in the past because I didn't know I was going to be racially discriminated against.
And Mr. Peterson in the Wisconsin Public Defender's Office, who's represented all of the plaintiffs in this case, furiously makes that argument every time this happens to one of his clients, and he's given the same answer, which is that you are procedurally barred from raising those constitutional questions now.
Can't you appeal that, though, and say, you know, if whether you're talking about equal protection or due process, can't you appeal that up the chain in the Wisconsin courts and say, yes, we can, you're wrong about state law, and if we're foreclosed from vindicating a federal constitutional right, the state procedural bar rule is unconstitutional itself?
My understanding is that those decisions have been upheld by the appellate courts. So really, there is no venue for raising these constitutional arguments in the state court. And I think that we have to look at what the Supreme Court said about narrowing this younger abstention doctrine in Sprint v. Jacobs, which is that the mere fact that you have something touching on the same subject matter in state court is not enough to apply the doctrine.
How many of the 6 criteria need to apply? And I'm specifically thinking commitment proceeding versus supervised release determination.
I'm sorry.
Of the Sprint criteria, there's a series of criteria that would apply, that would tailor the younger abstention. How many have to apply to a proceeding for it to qualify for abstention?
I think what the court was concerned about in Sprint is whether there would be interference in the state proceedings. And here, there just isn't any interference. The judge has already ordered the state to identify housing. DHS is coming back and saying, we can't, because there is no housing that complies with all of these restrictions.
Well, you
So
still have some time. I want to move you to the 11th Amendment question. Is the court responsible for enforcing the residency requirement, or is the secretary?
So, I mean, on some level, every law is ultimately enforced by judges, right? States attorneys don't really enforce the laws. They just bring the prosecution, and then the judge ultimately decides whether you go to prison or not. And I think that that's exactly what's the problem with the defendant's argument here, which is that the secretary of the DHS is intimately involved in every aspect of enforcing these housing restrictions.
But for example, the secretary is only one of 5 people on that county board. The board could still function without the secretary's participation. And you see where I'm going with this, because there's a real question, at least in my mind, as to whether or not the secretary is a proper defendant.
So I think that the ex parte Young requirement, and as this court has stated it, isn't an extremely demanding one. It doesn't have to be a person who has sole responsibility for enforcing the statute. They just have to have a special relationship to it.
What
And here
what about the redressability prong of Article 3 standing? What exact relief would you be asking the federal district court to enter?
an injunction prohibiting DHS from enforcing these particular residency requirements.
But DHS isn't the enforcement authority. The Attorney General is.
So-
DHS is the custodian.
I think the
It's not-
DHS has three important aspects of control over this statute. One, they are responsible for obtaining and paying for the housing of the person who is being released onto supervised release, and they maintain custody of that person. Two, they are a required member of every committee that is charged with responsibility for identifying the housing. And three, they are responsible for preparing the supervised release plan for the judge's approval. So there's no other state official, or any other official for that matter, that has that proper nexus to enforcement of this law like the DHS does.
DHS is the custodian when a prisoner coming off of a sex offense sentence is committed under Chapter 980. He or she is committed to the custody of the Secretary of the Department of Health Services. And DHS also administers the statute and participates in the programming and placement decisions for the offender, but is not the enforcement authority. That's the Attorney General, and the Assistant Attorneys General appear in these cases for the state. Isn't that the right defendant, to get to Judge Brennan's question?
I think under Ex parte Young, you just have to identify a person who has that special relationship to enforcement of the statute. And here DHS does, because they are ultimately responsible for obtaining and paying for the housing for anyone on supervised release. So I see I'm almost out of time, so I'll reserve my remainder.
That's fine.
Thank you.
Is it Keycaver?
Good morning. May it please the court. I'm Wisconsin Assistant Attorney General Carla Keycaver, and I'm appearing on behalf of Kristen Johnson, who is the current Secretary Designee of the Wisconsin Department of Health Services.
And before you jump in, let's just talk about who the right defendant is. If not your client, the secretary, which is what you're arguing, that there's 11th Amendment immunity, would it be the Attorney General?
I do not think it would be the Attorney General, because the Attorney General does not have enforcement authority over these particular statutes.
Or
It's
who
the
appears for the state in Chapter 980 proceedings?
Sometimes it's Assistant Attorney General, sometimes it's Special Counsel. It's not always it's the
Special counsel appointed by whom and operating under whose authority?
Perhaps it's the Attorney General, but
It's the Attorney General.
okay, fair.
You've got two former state.
At any rate,
here.
the Attorney General is not, they prosecute these cases, but they're not responsible for enforcement of the challenge part of the statute, which is those provisions relating to housing. Those are the responsibility of the counties. The counties are responsible for locating housing. And they're also
The
responsible.
county is not the enforcement authority. The county has a role under the statute to identify housing. But it's not the enforcement authority. The enforcement authority is the Attorney General.
Well, I would argue that the court has the enforcement authority, and maybe that's the case in all cases, but the court, especially in this case, once the county identifies housing, the court then orders the department to put the housing option in the placement plan. And the department has no discretion about whether to do that or not. And then the court assigns the various roles that the county is supposed to do and the department is supposed to do, and ultimately decides in its discretion whether to grant or deny supervised release. So I would disagree with my opponent that the case is not ongoing. The supervised release proceeding is ongoing today, and has been ongoing. The proceeding, the 980 proceeding, has been ongoing since the commitment proceedings. It's all one proceeding, and
Is that what the Wisconsin Supreme Court said in Alger, though?
yes,
That it was all one proceeding, or that should be looked at in its various components?
It
Because
said
Ms.
that-
Nicholas points out, I think it's 2009.
it said the commitment of Alger said that the supervised release proceeding is part and parcel of the initial Chapter 980 proceeding, so that the petition does not start a new proceeding. And if you look at the Chapter 980 proceedings, the court has an ongoing obligation to supervise that proceeding, including periodic reexaminations to make sure that the offender still meets the criteria to be a sexually violent offender and to be committed. So there's ongoing obligations on the part of the court. It's all one proceeding, same judge, same prosecutor, same defense attorney. The proceeding does not stop and start just because there's a supervised release proceeding. And I disagree with Ms. Nichols that there is no supervised release proceeding or no ongoing proceeding at this time. That proceeding is happening right now, and while the court found that the offender meets the initial factors for supervised release, the court has not granted supervised release and cannot grant supervised release until housing is located by the county and the next steps in the process are met.
Can Mr. Threlkeld raise his constitutional claims in the Chapter 980 proceeding in Kenosha County?
That is not in the record, and I'm not familiar with that.
Legal question.
Can he? Oh, can he?
It's a
I'm sorry.
legal-
I thought you
it's a legal
were
question.
stating that he did. Can he? Absolutely. He can raise those claims today and appeal them through to the Wisconsin Supreme Courts and then seek habeas review
And
potentially.
the Assistant Attorney General is not going to say those claims are procedurally barred because you didn't raise them at the time.
I don't think there's any authority for that. I don't know why. I mean, as Your Honor pointed out, there would be certain claims that you would not know about at the initial commitment proceedings. So, there are several cases that are good examples. They're in the brief on page 20. The in recommitment of West was the offender raised due process and equal protection challenges to the supervised release statute and appealed them all the way to the Supreme Court. Same with the Schulfius case, where the offender raised due process and equal protection challenges and appealed them. So there's cases that show that offenders can and do raise these claims right in their Chapter 980 proceedings.
And there's no appellate decision saying those claims are procedurally barred if not raised
Not
at
that I
an
know
earlier
of.
point in the proceeding.
I think opposing counsel pointed out, we raised one of the former plaintiffs, Hung Tran. The Wisconsin Court of Appeals stated that he could have raised, acknowledged that he could have raised constitutional claims in his 980 case, but then because he did not raise them below, the court declined to hear them for the first time on appeal. So seemingly they used that case to show that he would have had to have raised them at the commitment phase, but that's not accurate. He just didn't raise them at all below. So long as the case is ongoing and he has the ability to raise those claims, the younger abstention applies.
Yeah, I mean, and to the extent that the state court were to do something unexpected and say that it's barred by state procedural default rules, he could certainly argue they're unconstitutional as applied to him. Because it's truly a trapping effect at that point in time. Right? In other words, he has no way of vindicating, literally no way of vindicating a substantive right under the US Constitution. You'd say that's unconstitutional. I'm trapped here. So suppose, for example, we were having this exact same discussion 10 years from now. And Mr. Threlkeld had said, well, it was 4 years. It was 4 years in 2024, but now it's been 14 years. And nobody will listen to me about being released. I've been determined appropriate for release. I can't. At some point, you'd argue that the state law is unconstitutional for not permitting the federal claim to go forward.
I absolutely agree with that. And he could raise that claim in the Chapter 980 case.
But it
appeal
doesn't seem
through
we're
the
anywhere
state
near
courts.
a point like that. In other words, there's nothing in the record that I can see where Mr. Threlkeld seems like he could do it this afternoon. Goes in with a petition to say my continued detention under this configuration of housing requirements is unconstitutional for this reason, that reason, and some other reason.
Are you saying that you don't think he could
No,
raise
he
those?
could.
I agree.
He could
yes.
file that paper this afternoon.
I agree. And if that is denied, he could appeal it through the state courts and then presumably seek habeas review in the federal court if he's unsuccessful in the state courts once he exhausts those remedies. The Chapter 980 courts are also in a better position to adjudicate the plaintiff's constitutional claims because they're familiar with the facts on the ground, including the county's efforts to locate housing and the housing in the particular area, and then whether there might be alternative remedies available that might expedite the placement. And the state courts should be allowed to continue that work and continue their work without federal court interference. The district court properly determined that younger abstention applied and dismissed this case, and this court should affirm that decision.
Mr. Kickover, what if we were applying the Sprint criteria to just the supervised release component of Chapter 980? Wouldn't that be different than the civil commitment component of Chapter 980?
I don't think so. So in my mind, there are two steps to the younger analysis. There are the Sprint steps where you look at the type of proceeding, and then there are the Middlesex steps where you look at what's happening in that proceeding. And the Chapter 980 case fit neatly within the category of cases to which younger applies and that they're akin to a criminal prosecution.
If we don't ultimately agree with you that it's one long proceeding and it might be two separate proceedings, isn't it going to markedly differ the supervised release hearing from the civil commitment process under those both Sprint and Middlesex criteria?
If you were to look at the supervised release proceeding as a completely standalone separate proceeding, is that the question?
Mm-hmm.
I think it would still fit within the category of cases because itself is, it's still brought by the state versus the federal plaintiff is the target of the Chapter 980 action. Just like sentencing is still part of the criminal prosecution, it still has these, it's still the type of case where it's akin to a criminal prosecution. And so I think even if you think of them separately, it still has the flavor of a criminal case.
Do you want to build out what flavor means?
Well, meaning it's brought by the state. The offender is the target of the proceeding, and it also Chapter 980 proceedings are uniquely the province of state courts. So even looking outside of younger abstention to some sort of broader abstention type doctrines, this is the type of case that states should be left to handle. Unless the court has questions about our alternative grounds for affirmance, I would just ask this court to affirm the district court's decision abstaining on younger.
All right, thank you. Ms. Nicholas.
Thank you. The Supreme Court has narrowed the circumstances under which younger abstention is appropriate. It's not enough to just say someone could bring a claim in state court. State court could look at this issue. In fact, the Supreme Court explicitly said the pendency of an action in state court is no bar to proceedings concerning the same matter in a federal court having jurisdiction. So the question here is really whether there would be any interference with state proceedings. And these housing rules are not something that the state is deciding. They are just ordering the state, or not something the state court is deciding. They're just ordering the state to comply with them. The state cannot do so because they are impossible to comply with. That is something that's within this court's jurisdiction to consider, and the district court's decision should be reversed. Thank you.
Thank you. Our thanks to both counsel. The case is taken under advisement. Yeah. We'll just wait for things to settle down. There's obviously students who need to go to class. All right, our third case for argument this morning is Yang versus the United States. Ms. White, good morning.
Good morning. May it please the court. Singzai Yang's IQ has measured around the first percentile since he was first tested at age 9. It didn't improve after he was hit in the head with a metal cheese plow at age 18. When questioned after his arrest a few months later, Mr. Yang said that even he didn't know that he was going to rob a bank that day. During his pre-sentence interview, he talked at length about Edwin and Jason, the voices that exist only in his head. He has a long list of psychiatric diagnoses dating back to childhood and a documented history of hallucinations. He was prescribed 2 different psychotropic drugs during his prosecution, which he took intermittently. It is very likely that Mr. Yang was incompetent when he was tried, convicted, and sentenced to 14 years in prison. The question presented by this appeal is whether a trial judge has an independent responsibility to inquire into a defendant's competency. And the answer is yes. Competency and the right to be tried only when competent is a foundational right upon which our criminal justice system is based. It dates back to before the Constitution, but is clearly present in the Constitution, and the Due Process Clause protects that fundamental right. It's not simply the defendant's right. In fact, I cited an unpublished Wisconsin case in the reply brief in which a criminal defendant appealed a finding of incompetency, right? This defendant wanted to be found competent and was very upset that her trial counsel had offered opinions as to her potential incompetency.
Why not raise ineffective assistance of counsel here?
Ineffective assistance of counsel is at best a superfluous claim. That's what Anderson teaches us. There's no way to win, quote unquote, an ineffective assistance of counsel claim without the due process right having been violated, because ultimately what matters is whether we're trying an incompetent person or not. That's the substantive right that we care about. And I also think that an ineffective assistance of counsel claim, although certainly they have been raised in this context, I think it incorrectly frames the issue because, as I started out with, competency and the duty to ensure that we are not trying incompetent people is not just trial counsel's duty. It is a shared responsibility that the prosecutor and the judge also
can appeal that too, right? So if the trial court fails, let's just suppose you're correct, that the trial court fails to attend to that obligation. And you say, Judge, I have real questions about my client's competency beyond insanity, which is a defense we're going to pursue. I want my client evaluated. And the judge says, no, I don't have those same concerns. You can appeal that.
Correct. You
right?
can.
So you have it. You have a procedural out an avenue for vindicating the underlying constitutional right, appeal.
Yes, that is absolutely one procedural avenue to vindicate that right. However, it's not simply the defendant's right. It is more than that, right? It's more akin to jurisdiction. It is something that the judge, the trial court as a whole, the prosecutor also have an independent and shared responsibility to protect, because it's not just about the defendant's right. This is a bedrock principle upon which the
Yeah, but
entire.
the leap that I see that I'm having a hard time following is, given the avenues that are available for vindicating the substantive right, why should the law create an exception to established appellate requirements and established procedural default rules with respect to this particular right? That's the difficulty that I have with the argument.
I don't think that my position is asking the court to create an exception. I think what I'm doing here is simply asking the court to apply the rules that have already been announced through Supreme Court precedent and by this court, right? So we already know that the Supreme Court has clearly said, and this court has agreed, competency cannot be waived because it's antithetical to the idea of not trying incompetent individuals.
Right, but you don't impute a defendant's incompetency to the attorney, right?
Correct.
So in other words, because a defendant's incompetent, you don't assume an attorney's incompetent.
Correct.
You assume that the attorney is diligent and that the attorney would share the same concerns about competency and raise them both at the trial level and, if necessary, on appeal, and then possibly in post-conviction proceedings.
Yes, you would assume that. And you would also assume that the trial judge and the prosecutor would likewise raise those issues, especially whereas here it is in the record that this defendant has an IQ that is lower than 99.5% of the population, that this defendant has had hallucinations. The trial judge recognized those factors at the time when he, for example, denied at the bench trial, found that the NGI defense was not met by the defendant. The trial judge said on the record, I think there's something new going on now, which it is exactly what competency, right? That's like the difference between, one of the differences between.
What rule of law do you want us to announce here?
I don't want you to announce any new rule of law. I don't think that that is necessary. I think that the district court announced a new rule of law, parted ways with the Seventh Circuit, adopted the 11th Circuit unique framework for competency claims, and then didn't apply that framework correctly. That's where the issue lies. No new rule of law needs to be announced here. If you want to use this case as an opportunity to announce a different standard.
Well, okay, so what do you want us to hold?
I want you to hold that the district court erred when it denied the 2255 motion. And because there was a bona fide reason to doubt the defendant's competency, there needs to be a new competency hearing. The conviction needs to be vacated. And if the government wishes to retry the defendant, which I have no doubt they would want to do, there should be a competency hearing so that we can be sure that the defendant is competent before we try him and convict him.
Would that, though, necessarily require us to conclude that the district court was wrong when it rejected the point that due process competency claims are not subject to procedural default? So you have to be saying that reflects a legal error.
Yes, I think it does reflect a legal error. Due process claims, in my opinion, the Seventh Circuit has never held that they are subject to procedural default. And when we see Anderson, which is the most recent Seventh Circuit case, dealing with competency in the 2255 context, there was no discussion of procedural default. We have not explicit holdings, but a lot of suggestions, I would say, that procedural default does not apply to competency. I would also look at Cooper, which is a U.S. Supreme Court case in which the court said explicitly that we care more about not trying incompetent people than we care about judicial efficiency, which is within the 2255 context, the purpose of procedural default. So I don't think the Seventh Circuit has never said that procedural default applies to competency claims, and I don't think you should hold that they apply here. But even if you were to agree with the district court and follow the 11th Circuit's framework, which says that procedural default applies to some competency claims, what they call procedural competency claims, it still would not bar Mr. Yang's claim here, because if we're going to follow this framework of procedural versus substantive competency claims, this claim is a substantive claim. We are not simply arguing that the proper procedure wasn't followed. We are saying, and we have an expert testifying at the post-conviction evidentiary hearing, saying he thinks it is very likely that Mr. Yang was incompetent at the time that he was tried, convicted, and sentenced.
Where I'm struggling, Ms. White, is between the court, the prosecutor, and the defense counsel. The individual who knows those competency issues the best would be the defense counsel. So with a lot of this extra record evidence that would come in at an IAC hearing. Here, the district court clearly raised it during the 2255 evidentiary hearing. The decision was made not to waive privilege. So that whole font of evidence that might come in with regard to Mr. Yang's interaction and whether it was going up or down or improving or denigrating just never gets before the court.
I would respectfully disagree that defense counsel is the expert on competency. I do not consider myself an expert on competency. That's why we have competency evaluations that are ordered.
True, but the defense counsel among those three is by far spent the most amount of time with that client.
Hopefully, although that may not always be the case. But I would again point this court to Anderson, in which defense counsel did testify. There was both a due process claim and an ineffective assistance of counsel claim raised concerning competency. Trial counsel testified that they did not see an issue and did not raise defendant's competency because they didn't think there was any potential incompetency. And that didn't matter. This court still said there's bona fide reason to doubt the defendant's competency. You need to have a hearing. And after a hearing, the district court, following this court's ruling, vacated the conviction and said we need to have a new competency hearing. And then if the defendant is found competent, the government can retry him.
Ms. White, I want to ask you a question. I'm going to be careful with the way I ask this because I'm not trying to get into anything privileged or confidential at all. Okay. But one thing that has worried me here is this possibility that the reason that Mr. Yang is not pursuing the competency claim through ineffective assistance and not waiving privilege is because he's made that choice. In other words, he came to counsel and said, I will not waive any privilege, any confidence, anything with respect to the pursuit of competency-based relief, and therefore has put counsel under an instruction not to waive attorney-client privilege when trying to vindicate that right. I don't see any indication of that in the briefing. Is that right?
Well, I will answer very mindful of my duty of confidentiality. One of my duties, one of my ethical obligations, is to assert attorney-client privilege. I have that duty. It's not something that I get to choose. I have to assert that privilege on behalf of my client. And that privilege cannot be waived without a knowing, voluntary, intelligent waiver. And an incompetent individual cannot waive that privilege. And so we're really caught in a bind here, right? I have a duty to assert that privilege on behalf of my client. My client cannot waive that duty. And again, I would go back to the fact that an ineffective assistance of counsel claim is superfluous. That's what Anderson says. Anderson said, we have this due process claim. We think there's a bona fide doubt as to the defendant's competence. Therefore, a hearing is required. That's it. We don't, the ineffective assistance counsel claim has a higher standard, more things to prove. We can go through that standard, but ultimately it doesn't matter because the due process claim is what does matter. I would like to reserve the remainder of my time for rebuttal.
That's fine. Thank you. Ms. Ford.
Thank you, Your Honor, and may it please the court. I'd like to start with a brief point on procedural default and then turn to the merits. Procedural default applies generally to all claims raised for the first time on collateral review. So as your question suggested, the question here is, should the court carve out a new exception to that general rule? And Yang hasn't identified any reason to do so. He says direct review is not feasible because competency claims rely on extra record evidence. But procedural competency claims, the only kind that Yang has meaningfully raised here, don't require any extra record evidence. The entire question is based on the evidence that was before the district court at the time. On the merits, Yang has not identified an abuse of discretion or clear error on the part of the district court. Competency is a functional test, and the district court rightly concluded that there was no bona fide doubt as to Yang's functional ability to rationally understand the proceedings and consult with counsel, particularly given the affirmative statements by two experienced defense counsel that they had no doubts as to Yang's competency, in addition to Yang's pro se letter and the extensive expert evidence of malingering. So even if the court does reach the merits, it should affirm. I welcome the court's questions, or I'm happy to move on to a few further points.
You think this case implicates any of the hypothetical fact patterns that I'm worried about, where you have an incompetent defendant, just stipulate that you have an incompetent defendant that is providing instructions to his counsel about how to litigate that are flatly at odds with his interests. And he doesn't realize that because of his incompetency.
Your Honor, I don't think the court needs to address those points here. I do agree that the questions about waiver and the client's ability to waive are wrapped up in issues of competency. And so, as the Supreme Court explained in Pate, you have to act knowingly and intelligently to waive something. But of course, that's a distinct concept from procedural default. Procedural default doesn't turn on the subjective understanding at all of the defendant. It's motivated by principles and finality and judicial efficiency. And as this court's questions were noting, there are many avenues available to defendants who do want to raise these types of claims.
Yeah, the reason that I don't think it's implicated here for a couple of reasons, but one primary one is, if I'm correct, Mr. Yang himself filed a pro se 2255 where he wanted to press ineffective assistance.
That's correct, Your
And
Honor.
ordinarily, when a defendant does that, you assume that there's an implicit waiver, kind of, to litigate the merit. So, now it's been, the attorney-client privilege has been asserted by counsel now, but there's no indication from this procedural path that even if he's incompetent, he's providing instruction to his counsel that could be entirely at odds with his interests.
That's possible, Your Honor, again, because the two earlier ineffective assistance claims, which were raised in the two earlier versions of the 2255 motion, those are no longer before the court. Again, I don't think the court needs to reach that issue. I will also note that the government's position is it wouldn't be necessary to call Attorney Phillip on anything that would be covered by the attorney-client privilege if this court were to, of course, rule against us on the merits and on procedural default and have some form of remand. And that's because we do have his bottom line position here. He's made clear that he had no doubts as to Yang's competency to proceed. And of course, this court has recognized that a district court can give that significant weight in determining whether or not there was a bona fide doubt to proceed, and it rightly did so here.
One of the challenges, Ms. Ford, though, is competency changes. Not guilty by reason of mental disease or defect goes to that actor's state of mind at that moment when he walked into the bank. But here, competency can change for organic reasons. It can change for medication reasons. It can change within the course of a determination to a jury trial, bench trial, et cetera. Given that changing nature of competency, I'm wondering whether or not the record that we have before us would, whether there was sufficient analysis of the record before us to ensure that there was competency at the appropriate times for this defendant?
Your Honor, I think there was. The district court did acknowledge the psychiatric diagnoses in the record. That's at page 17. The district court did acknowledge the taking of medications as well. That's at page 16 of the opinion. And I would just note that because competency is this functional test that could change over time, the district court was rightly considering those points in the record through the lens of two important contextual factors. And the first is that extensive expert evidence of malingering. And that's not just as to memory deficits, but also as to the auditory hallucinations and other symptoms of psychosis that we know form the bases for the relevant psychiatric diagnosis and the psychotropic medications, which I'm happy to touch on more too. But the second contextual factor that's important is that there was lots of affirmative evidence that this defendant was able to rationally understand the proceedings and interact with his counsel. So you have Yang's pro se letter, you have the post-offense interview, you have the pretrial services interview, you have the district court's own in-court observations of the defendant. And I'd note those were not just yes or no back and forth. There were colloquies that were substantive, including at the change of plea hearing. And so when you put that full picture together, I don't think there was any abuse of discretion for the district court to conclude that there was no bona fide doubt as to competency here. I would just note on the psychotropic medications, it's actually important to drill down a little bit on what was there. So you have only a period of a month and a half. This is noted in Dr. Johnson's report at page 2 to 3, where the defendant, this is about a year before trial, where the defendant was receiving those medications because he was claiming to have auditory hallucinations. And after that period of a month and a half, you see from the prison records, which were summarized in Dr. Johnson's report, that because the defendant was no longer claiming to have auditory hallucinations, that those medications were actually stopped at that point, and the prison records note that there is no further evidence of a psychotic disorder. So the district court could have rightly been viewing those medications in line with the evidence of malingering that we do see throughout the record and that both experts attested to.
At what point in the proceedings did that happen?
I'm sorry, can you repeat the
At
question?
what point in the proceedings did that happen?
Sure. So that was about a month before the change of plea hearing. And we know at that change of plea hearing that the attorney representing Yang noted that he had no doubts as to the defendant's competency. So that's further evidence that if, during that period of a month and a half when he was taking the medication, there were issues that were arising, you would expect defense counsel to actually raise that. I would just note a few further points. One, Anderson came up earlier. That case does not help Yang, and that's because procedural default can be waived, and the government didn't raise procedural default in that case, so the court really had no occasion to consider whether or not to apply procedural default. The next point I'd make is that I think there are a lot of safeguards to ensure that these types of claims, when they're meritorious, are in fact raised and addressed. So you've got the triple protections at the district court level, not only on an obligation on the district court, but the defense counsel and also the government attorneys. Of course, ineffective assistance of counsel claims are also available to a defendant if defense counsel does fall down in their duty to raise those claims. And procedural default is also not a bar. Defense counsel could have argued cause and prejudice to overcome that bar here, and Yang simply chose not to do so. And then finally, I would just note on waiver, that's a analytically distinct concept. As I was noting before, it requires that a defendant act knowingly and intelligently. And so the analysis regarding waiver really doesn't extend to a competency claim. If there are no further questions, Your Honor.
Thank you.
Thank you. I would ask the court to affirm.
Ms. White.
Thank you. The government mentioned waiver. The Supreme Court has clearly held that competency cannot be waived, cannot be voluntarily, knowingly waived, right? If you're incompetent, you're incapable of waiving. If you're competent, you can't waive your right to be tried only when competent in advance of becoming incompetent. That's what the Supreme Court has held. Procedural default within the 2255 context focuses essentially on forfeiture, right? So it's not necessarily waiver, but it's forfeiture. It's the negligent relinquishment of a right. I do not understand how an incompetent individual who is incapable of knowingly, voluntarily waiving a right somehow could be found to negligently forfeit that right. That to me does not make sense.
Do we know why he didn't appeal? And as Judge Scudder has pointed out, this is the sort of issue that can be raised on direct appeal.
It can be.
It takes this outside of the context of the Anderson case where there was an appeal waiver and the
Yes.
government did not assert procedural default as a consequence, or I assume as a consequence. But do we know why he didn't appeal?
That's not in the record. The decision to appeal is a decision that a defendant has and can make, and an incompetent individual may have difficulty making that decision, right? There's a lot of questions like that. I see my time is up. Thank you.
Thank you. Thanks to both counsel. The case is taken under advisement. And we'll move to our fourth case this morning. Nicholas Gash versus Rosalind Franklin University. All right, the room is quieting down. Ms. Davis.
Good morning, and may it please the court. My name is Tara Davis, and I'm here on behalf of the plaintiff, Nicholas Gash. This matter comes before your honors today because the district court improperly granted the university's motion to dismiss the plaintiff's amended complaint. Plaintiff is requesting a reversal of those portions of the district court's decision which granted the motion and dismissed his Title IX and breach of contract claims. The district court's decision should be reversed because the amended complaint plausibly alleged both a Title IX and a breach of contract claim. When assessing a 12b6 motion to dismiss, the court must accept all factual allegations in the complaint as true, must construe the complaint in the light most favorable to the non-moving party, and must draw all reasonable inferences in the plaintiff's favor. The district court failed to do so here, warranting a reversal.
Ms. Davis, what was different about this situation for your client because he was a man?
So a number of things, starting with the decision to investigate the matter from the beginning. This alleged conduct occurred off campus, and the university's Title IX director decided to have the matter investigated and adjudicated. That was the first in a series of procedural irregularities, all of which went against the plaintiff and none of which went against the complainant, Jane Rowe.
Does that make it accuser-centered versus male-female centered?
So at this stage, and based on the number of procedural irregularities that occurred, again, all of which went against the plaintiff and adversely impacted him alone, and none of which adversely impacted the complainant, Jane Rowe, there is a plausible inference that it was based on gender bias. And some of the other irregularities I'd like to point out occurred during the hearing and adjudication process. This included the removal of both parties from the hearing during the testimony of the witnesses. Like it's contrary to the regulations, but it was both parties. It was both genders. That's correct. It was contrary to the regulations and both parties were removed from the hearing. However, the significant point is that the parties were not similarly situated, meaning the plaintiff, as the accused, was in a much different position and had much more to lose should he be found responsible, which he ultimately was, and sanctioned, which he ultimately was, with an expulsion. There is a reason that the Constitution provides for a right to confront witnesses to an accused. There is a well-accepted precedent and recognition that an accused is in a much different position, and his inability to hear the examination of the witnesses, all 5 of which were adverse to him and were identified by the complainant, Jane Rowe, severely impacted him and led to a finding by the hearing panel that he was responsible. Also during the hearing—
That sounds like an argument to me that the procedures that are applied or were applied are problematic in your client's view, but what evidence or what is there that would allow an inference that the application of the procedures was because of his gender.
So the important point to keep in mind is that, as this court discussed in Doe versus Purdue University in 2019, the court has to look at the totality of the evidence. So even if we look at just this particular fact in isolation, if that's not sufficient on its own, it's really a matter of whether, when all of the facts alleged are considered, is there a plausible inference of bias? And some other errors that occurred during the hearing, I think, further highlight the impact to the plaintiff, the male accused alone, including the fact that his advisor was continually prohibited from asking the complaining party any relevant questions. So critical, objectively relevant questions, such as those that related to the alleged misconduct. He also was
Do you
prohibited.
see this case as factually similar to Purdue?
There are some similarities. It's a different factual background. There's no, set list of facts that have to be established to meet the plausibility thresholds for a Title IX claim when faced with a motion to dismiss. But I think there were equally concerning errors that occurred here, particularly during the hearing process, some of which I just mentioned, in addition to the fact that the plaintiff's advisor was not able to question the complaining party, Jane Roe, about anything she said in her opening statement, which presumed that what she was claiming had happened was true. So when plaintiff's advisor attempted to ask questions to point out inconsistencies or things that she had said that made her account not credible, that she had said during her initial opening remarks, he was prohibited from doing so. He also was prohibited from asking the quote unquote outcry witness about what the complaining party had told her. So there were just a number of errors that occurred during the hearing process, again, all of which went against the plaintiff only, and which prevented his advisor from exploring the credibility in Jane Roe's account. The hearing panel also ultimately found that the plaintiff was responsible, as I mentioned, and expelled him. But what they failed to recognize was that it was undisputed that the plaintiff was incapacitated by the university's own definition, meaning he could not and was not capable of consenting to sexual activity. The hearing panel disregarded this entirely. There was no discussion about it. It wasn't even mentioned in the hearing panel's decision letter. So that's another indication of how the male accused was treated differently, and again, plausibly suggests that gender bias was a potential motivating factor here. The investigator also conducted an investigation that was far from thorough, which further raises another procedural irregularity. And she failed to fairly summarize the relevant evidence, which is another violation of the 2020 Title IX regulations. And the way that she conducted her investigation was by conducting interviews with the parties. There was no follow-up. There was no probing questions that were asked of the complaining party, Jane Roe. And ultimately, she produced a report that was about 5 or 6 pages. It really lacked in any substance. The hearing panel further, or I'm sorry, rather, the one other point I wanted to raise, and something else that was discussed in Doe versus Purdue, was the external pressure that was created on the university. So the 2011 Dear Colleague letter led to a sea change in how universities handled and responded to sexual assault complaints. And the atmosphere that was created persists to this day. So whether there have been a rescission of the rules or they're currently undergoing proposed rulemaking changes, that atmosphere and the culture that impacted campuses and the university's concern about being subjected to an investigation or having federal funds withdrawn, that continues. And that's, again, not something to be viewed in isolation, but rather viewed in the totality in light of all of the circumstances to determine if there is a plausible inference. Again, we're at the motion to dismiss stage, so not whether the plaintiff may ultimately prevail on a motion for summary judgment or at trial. But at this point, is there enough to plausibly suggest that there was a gender bias motivation, enough to get him past the hurdle of the initial motion to dismiss and to be able to conduct discovery in this matter? And unless the court has further questions, I'd like to reserve some time for rebuttal.
That's fine.
Thank you.
Ms. Smith?
May it please the court, Jennifer Smith for Rosalind Franklin University. So first I want to address this concept raised by counsel that there was different stakes for the parties, and so procedural errors hit them differently. The stakes for the parties were access to education for both of them. Title IX says those who are subjected to sexual harassment must be corrected and or addressed so that they continue to have access. So there's no difference in stakes. The stake was access to education for both
There's
parties.
a difference in consequences.
What's that?
There's a difference in consequences. A student who's accused of sexual assault or sexual harassment, some other sex-based offense that implicates Title IX, is subject to a whole array of discipline, including up to and including expulsion, which is what happened here. The
Right.
complaining party is not.
A
I
complaining
think that's
party,
what the argument pertains to.
but the stakes are just as severe. A complaining party
Okay, let's
who
change
has
the word to
go-
consequences, okay? What are the consequences of this proceeding?
The
The consequences for
of
the
proceeding for
respondent
the
are severe.
complainant.
The consequences for the complainant are non-existent.
No, they're going.
They're
continuing-
cost-free.
They're seeing the person who sexually assaulted you in class and having a safe learning environment.
I'm talking about the proceeding itself. What
Yeah,
are the
that-
consequences that flow from the proceeding? There's no downside consequence for the complaining party to falsify testimony.
Yes,
Right,
there
but
is. There's, a complaining party can be subject to discipline for falsifying testimony. That is absolutely also violates rules. But they would be subject to their own disciplinary hearing.
Okay,
So,
but the consequences for the parties in this proceeding are one-sided. Only the respondent is subject to sanctions at the end of the process.
well, the parties in this proceeding are the university, and the university has a interest, that's fundamental to education, to providing a safe learning environment. So in this case, but at the proceeding, at the Title IX proceeding, we disagree that the complainant did not have an interest in the outcome.
Well, I'm not talking about an interest in the outcome, and I don't think that's what your opponent's argument is. The argument is that the accused has more to lose in this proceeding than the complainant does. That's just self-evident, right?
I don't think it is, but I've said why, and so I'll move off that point. So when we're looking at the Title IX case, the question is gender discrimination, not a redo of, and whether the university discriminated, and that was evident in some of your questions. And so it was brought up the totality of the circumstances. Does it suggest gender discrimination? There was no explicit, statement in the complaint that there was some reference to gender, but instead the allegation is the totality of unfairness alleged amounts to gender discrimination. First of all, the supposed many errors, even as alleged, are not errors. So I want to first address the alleged public pressure. This case is different from other cases that have come before because of the timing.
And if we grant you that, I'd like to move you to another alleged area.
Yeah.
And that's the jurisdiction. Off-campus bar drinking, off-campus allegations of sexual assault, not a university-based event. If the university does not have jurisdiction, what consequences would that have for this proceeding?
So jurisdiction under Title IX is different than jurisdiction to address the conduct. So that's where I'm confused by the argument, because they're saying Title IX does not apply, does not give the requirement that the university address that conduct, but Title IX doesn't prohibit the university from having its own policy
But
or
what's that
state law.
policy of RFU identical to Title IX? It was the same language, right?
Well, what we know, because we're at the motion to dismiss stage, is they had a policy that, according to, as it's alleged, addressed both Title IX and equal access to education. So it could be identical, or it could not be, but there would be no harm. Title IX at this point, after the 2020 regulations, provides respondents, those accused, with more robust rights and process than is afforded in any other area of student misconduct. So to give Title IX rights to the plaintiff at the hearing stage would only give him more process, more protection, and wouldn't be a procedural violation that showed gender discrimination. It would be a pro-respondent
I think the question
application.
is whether the university extended its jurisdiction to adjudicate this complainant's complaint to an off-campus event over which it did not have substantial control, which is the test under the regulations and under your policy,
Right.
your client's policy. And the irregularity of that is what the plaintiff argues is suggestive of sex-based violence, or I'm sorry, sex-based bias in this case, because they extended the hearing administrator extended the university's jurisdiction to an off-campus occurrence that it doesn't have any jurisdiction over.
It does have jurisdiction. Just because
It has substantial
They
control
found-
over an off-campus.
when a student
apartment?
complains another student sexually harassed them and complains to the university about the impact that's having, here as pled, the appeal that was considered an appeal. The party appealed beyond the hearing, and the university looked at that issue and said, we did have jurisdiction over this conduct, and we were right to discipline you for it. And again, whether or not that falls under Title IX or its policy that's pled, there's a policy that might have, we don't have the full policy, but he acknowledged, the pleadings acknowledge a policy. It doesn't harm or show gender discrimination.
Is it a breach of contract?
No, it's not a breach of contract either, because we have no allegation that there was some contractual guarantee to not disciplining someone who sexually harasses their fellow student. And
the policy only applies, and Title IX only applies to occurrences over which the university, at locations at which the university has exercised substantial control.
And that is not equivalent to off-campus. Substantial control can mean different things, and in other cases have been found to be off-campus conduct. And here, this university reviewed that issue and found it did have jurisdiction over this conduct.
The complaint alleges that this was procedurally irregular because of what the policy says and what the Title IX regulations say about the university's jurisdiction to adjudicate these complaints. So is that not something we just accept as an allegation in the complaint, rather than try to resolve it at this stage?
They don't allege that it's conclusory to say it's irregular. They don't allege other cases where there was a female respondent and they did not pursue it because it was off campus. There's, other than their conclusory statement, this is irregular, we have nothing on that point. And it's self-evident in the Title IX regulations that say universities are not restricted from addressing things that are beyond the scope of our regulations. So with that, my time is called.
All right. Ms. Davis, you had some time in rebuttal.
Thank you. Counsel for the university claims that the alleged procedural errors were not necessarily errors because, or at least that the complaint didn't allege that. And when saying that the procedural errors were irregular, what we mean by that, and if the court has any questions on this, I'm glad to clarify, but we mean that it was not in line with either the Title IX regulations and or the university's policy. So the complaint in our briefing makes clear that there were, again, a number of procedural issues or errors, again, all of which went against the plaintiff and none of which went against Jane Roe, the complaining party.
What if we had all of these irregularities as argued and the accuser and the respondent are flipped? What about the maleness or the femaleness inserts the gender aspect?
So I think one of the more significant points is the fact that the university found or failed to investigate or look into whatsoever the fact that the plaintiff, the male accused, was incapable of consenting. Again, this issue was undisputed. It was made known to the Title IX director and the investigator early on in the process because it was included in Jane Roe's own statement in the investigation report, and they failed to take any action despite having actual knowledge of that. So I think if the roles were reversed, I think it would be clear that if the university had information that a female student was incapable of consenting by the university's own policies to the point that she had no recollection of a period of 7 to 8 hours that night as to what happened, I think there's a decent presumption that the university would take steps to address that. So that in particular is one issue that I see as being particularly indicative of gender bias. And I see that my time is up. Thank you very much. And again, I would just respectfully request that the court reverse the district court's decision.
Thank you. Our thanks to both counsel. The case is taken under advisement, and we'll move to our fifth case this morning. Christine, I think it's Boubet and Connie Hendrington versus Aspirus Hospital.
Good afternoon.
We'll just wait for the room to quiet down a minute. All right, I think the class change has completed. Mr. Erickson, you may proceed.
Once again, good afternoon. May it please the court, counsel. My name is Greg Erickson. I'm from Mormon, Cardall, and Erickson, and I'm representing appellants Christine Boubet and Connie Hendrington. The single issue that is before the court today is whether or not a district court may dismiss a complaint under Rule 12b-6 standards when the complaint, in its terms, has pled sincerely held religious beliefs that conflict with the employer's vaccine mandate. Aspirus Hospital had a vaccine mandate for its employees, similarly to hospitals and healthcare associations all across this country. The distinction between the Aspirus Hospital vaccine mandate exemption process and virtually any process that I've seen, and I have 150 plaintiffs in cases against a number of healthcare systems, so I've seen quite a few of these. The massive distinction between Aspirus's policy and policies throughout other healthcare institutions is the fact that Aspirus decided to make limits on its employees' ability to successfully plead their religious conflicts with their vaccine mandate. And they're stated in our reply brief, and I'll give you a few examples.
Yeah, just in the interest of time, Mr. Eric, can I just ask you a very specific question on that? I have a hard time following that because when I look at the initial exemption requests that were submitted by both of the clients here, and then there's this kind of, what do you call it, like an appeal, an administrative appeal or administrative review, seems as clear as day to me what they're asking for.
No.
So I don't understand the point you're making about Aspirus's process being deficient in some way.
Well, let me explain. First of all, the process only allowed employees to make one religious conflict with the vaccination requirement.
Okay.
There's absolutely nothing in the law that would allow them to do that. All the cases specifically
Hold on,
say
that. What's the problem? Say it again.
the Aspirus policy specifically said that they are only able to cite one religious conflict with vaccination. Okay? That's an extremely important distinction between their policy and any other healthcare facilities policy. Okay? Another problem with their process is they made specific references to not use references to scripture unless you were able to clearly and concisely connect them with their objections to vaccination. Well, Your Honor, the Bible is a 2,000 to 5,000-year-old text that, in essence, existed long before vaccinations were even contemplated, 200 years ago? So when they make statements like that in their policies, it makes it extremely difficult for employees to properly craft their religious exemption requests.
This is where we're on two different wavelengths here. Because when I read the two exemption requests that were submitted here,
okay,
they're clear. Religion it's right in the text of them. People articulate why it is they have a religious objection to the vaccine. And it's odd to me that you're starting your argument. We were together a few months ago, you'll remember.
Okay.
It's odd to me that you're starting this argument with a procedural point about Osiris's process, as opposed to what I understood from your brief was read the exemption requests. There are absolutely religious objections.
100%, Your Honor. But the district court, when it absolutely parsed these religious exemption requests into little pieces and then made conclusions, factual conclusions, which they are prohibited from doing under Rule 12 in relation to these exemption requests, in support of its decision to dismiss, I just feel that that's completely inappropriate when their policy restricted the effectiveness of the requests. And then, well, obviously, if this court believes that they clearly and concisely put their religious conflict with vaccination in their...
Your argument would make a lot more sense to me if it was Aspirus only provided one line. You could submit a one-line email articulating your religious objection to a COVID vaccine. You would say they're absolutely impossible. There's just not, you can't say enough in one line. But that's not at all what has happened here.
Well, Your Honor, what about the fact that they attacked they attacked the fetal cell arguments with misinformation in their communications with their employees? And that is specifically referenced in our complaint with the letter from the Thomas More Society that was provided.
I think your fetal cell the problem with your fetal cell or your client's issue with it is that the exemption requests and the related appellate communications don't reference that objection. An objection on that basis, anyway.
That was the fetal cell objection was in the complaint for Ms. Hedrington. We pled it.
You mean the district court complaint?
Yes.
Oh, okay, fair enough. But what you're alleging here is that through this exemption request process, right, there was religious discrimination that occurred.
Correct.
Okay, and my only point is that in the communications that occurred to the employer through the exemption request outlet, there's plenty of references to religion, but not about fetal cells.
Because if the employer says, I'm not going to listen to any fetal cell arguments in their communication to you, obviously that's going to have a material effect on the party's ability to make their requests.
Mr. Erickson, I want to pick up on something you said earlier. IDEA says can't be surgical in the way these things are looked at.
100%.
Reed is the other side. Reed is saying, wait a minute, how do we protect against someone saying that there's not sincerely held religious belief? I think it's what white walls and shades is mentioned. Where are we to draw that line as to every belief or preference not becoming protected religious versus what is appropriately protected religious?
Your Honor, I'd say for the Rule 12 inquiry, which is what we're dealing with here, when we have employees that specifically plead religious beliefs that conflict with the vaccination requirement for Rule 12, the analysis ends just right there. Perhaps this analysis that the district court engaged in is appropriate at summary judgment, okay? Obviously, it's appropriate at trial, but certainly not in the Rule 12 context when you have a completely and fundamentally undeveloped factual record. It's virtually impossible to properly evaluate an employee's religious beliefs when there was no interactive process that occurred between the employer and the employees, which is required under the, I think it's city versus Chicago, Porter versus City of Chicago. The Seventh Circuit specifically said that employers are required to interact directly with their employees. When they don't do that, okay, and the employee pleads.
Title 7 or ADA?
Pardon? Title 7. This was a, okay. So when an employer makes a decision to terminate an employee based on a religious exemption request that specifically targets their religious beliefs and the vaccination requirement, that should survive Rule 12. I'm going to reserve the rest of my time for rebuttal.
Thank you. Leibniz.
Your Honor, thank you. My name is Chad Leibniz, and I represent Aspirus Hospital Incorporated in this matter. The appellants in this case requested that they be exempt or be excused from Aspirus's mandatory vaccination policy. The basis for this excuse was on medical or personal reasons, not based on sincerely held religious beliefs. Therefore, there is no facially plausible claim that was articulated either in the original exemption request or in the complaint.
Mr. Leibniz, if there are religious reasons given, bodily autonomy reasons given, efficacy reasons given, a third, is that automatically disqualify that from being an exemption?
Not automatically, Your Honor.
What percentage then must be religious to invoke the exception?
I don't know. I think it's a sliding scale, but if you look at Ashcroft and you have to engage in a specific context analysis, and you have to really look at the facts and the submissions before you in each instance. In this case, you can see, as opposing counsel pointed out, Aspirus was really focused on providing guidance to their employees on how to properly put in or submit a religious exemption request. If you look at both Ms. Hedrington's and Ms. Boubet's original exemption requests together with their appeals, they start out by focusing on the personal beliefs or the medical beliefs. For example, I believe Ms. Hedrington starts out, it's my body, my choice. No one is going to tell me what to do. In the case of Ms. Boubet, she says, I'm a practicing Catholic, but then she goes in about how she's already obtained the COVID vaccine and she has antibodies and it's unnecessary for her to receive the vaccine. These are all personal medical beliefs not sincerely
What I
held.
worry about with that line of argument is going to Judge Brennan's question is, I think you're right in part. I don't think there's any question about that. But are you right in whole? So if you look at Miss Hedrington's, right, you know it very well.
Correct.
Okay. I think your description of it is fair, that it is the way but then as it proceeds, and when you incorporate the appeal, by its terms, that my body, my choice, free, all that, it gets linked to religion. Does it not?
It never gets linked, Your Honor. It never gets linked. They try to tie this back to the specifics of their requests. So, for instance, in Ms. Hedrington's appeal submission, she states, God is my creator. He created me upon conception and designed my body and immune system in the womb. The district court got this right. The specifics that they talk about in each instance, the appellants, are medical and personal. When they move into the religious aspect or the religious side of things, they speak in generalities. There is never a link. And I'll give you another example of that, Your Honor. I believe it was Ms. Boubet who attached the Catholic Catechism to her submission. And it says, I can act morally in my conscience as I see fit. And I'm enjoined or precluded from doing evil. But there's never a link between why the COVID vaccine and the employment requirement of receiving the vaccine is somehow evil. There's never a link between the two.
Well, go to Ms. Hedrington's, right? I think one thing we got to be very careful about is reading these email submissions or these, the submission. We got to be careful about reading them like, income tax regulations.
Your Honor, are you on
Finally, but
her original submission or appeal?
her appeal. Okay. She says in there, after everything that you focused on, and I understand why you're focused on it, she says, that is not what God desires for me. I think the only thing that can refer to is what she's talking about, getting vaccinated. And she says, accepting this vaccine goes against my deeply held trust in God. It just seems on its face that it's religiously grounded in part.
And getting back to Ashcroft, to do this on a specific context analysis, we have to analyze this based on common sense and judicial experience. I would take that, the concept that the court just cited, and you have to step back and look at the overall intent of what this individual.
We also have Rule 8A, and this is 12B6. We've got to view it in the light most favorable to the pleader, and that's the plaintiffs here. And you're asking us, it seems to me, to look at it from the perspective of a summary judgment determination.
Well, I think one indication of why this is a perfect 12B6 motion, as you can see, if you go back in the complaint, what the appellant's counsel tries to do is buttress some of these arguments. So in other words, there is a citation in the complaint that there was an objection based on abortion and fetal cells. That was never included in the original exemption request. The reason for that is they're concerned that this is a 12B6. The most important aspect that we have to consider is the actual exemption requests and appeals. This is a unique situation. Most of the time you're looking in the four corners of the complaint for a 12B6. Well, they can't retroactively change what those submissions were. And that's why this is a very, very unique situation.
Did the hospital prohibit them from asserting the fetal stem cell rationale?
I'm sorry, Your Honor?
Did the hospital prohibit its employees from relying on the fetal stem cell rationale for requesting a religious exemption?
They did not. If you look, I know
that was nowhere in the instructions for filling out a religious exemption form.
And I'm just looking at, this is the appendix that the appellant submitted, appendix 18, right? They include the guidance. It's called guidance, not restrictions, that Aspira shared with everybody. Applicants are encouraged to do the following guidance. This may result in a denial. The important part is drawing a link between the sincerely held religious belief and the conflict. This is a
And
spirit.
what did the guidance say about the fetal stem cell rationale for religious exemption requests?
So I'll read it. It says misinformation such as microchip, magnets, DNA altering technology, use of animal cells or tissue in vaccine developments, the presence of fetal cells or tissues in the vaccine.
Calling that misinformation
Correct.
guidance, but calling it misinformation.
And Your Honor, it might not, this was a world of COVID where we were trying to figure out, we were trying to fly the ship or fly the airplane while building.
Understood,
So,
understood.
but that, Your Honor, is correct. And
Okay, but the reason we check for religiosity and sincerity in any of these religious discrimination claims, whether they arise under Title VII or RFRA or RLUIPA or the First Amendment's free exercise clause. Those are the legal sources that animate these claims. The reason we test for religiosity and sincerity, and it's a light touch test necessarily because we can't look behind the religious belief and examine it, certainly not for truth, and not even for consistency with some religious doctrine. That's strictly prohibited by the Supreme Court's jurisprudence in this area. We test for religiosity and sincerity to weed out sham claims. And so to uphold the district court's decision in this case, we would have to say that on the face of these exemption requests, this is a sham claim. What's your best argument for that conclusion?
Your Honor, I wouldn't necessarily conclude that you would have to call it a sham claim. I would say you look at the exemptions themselves and you look at what they are based on, both in the original exemption requests and the appeals. They start and they end with the basis of a personal or medical decision.
In the request that was at issue in the Adeyeye case, the employee's request for time off to go to his home country for purposes of funeral rites for his father, it was the religious components of that were highly generalized, not tied to scripture or catechism, highly generalized, loosely related to some form of Christianity and the traditions and customs of his village in Africa. If that was good enough to survive 12b-6, why aren't these exemption requests good enough to survive 12b-6?
Because there wasn't the counterbalance of, on its face, personal and medical beliefs. It was generalized in Adaya, but there wasn't that counterbalance.
I'm not sure I understand that answer.
Here
What
you
do you
have
mean by counterbalance?
you have a tension between the personal, medical, and the religious.
In that case, there was a tension between filial responsibility and the religious demands. Same kind of tension. A non-religious explanation for the request and a religious explanation for the request.
In this case, I believe the balance is on the side of personal and medical. In that case, it was on religious.
Except that was a 12b-6 and we reversed and said, this is for a jury to decide. Why would that not be the case here?
I'm sorry?
Why would that not be the case here?
Because
Why is the
you
court
look-
striking the balance instead of a jury?
because it's so obvious here that it's a personal medical belief. And in this instance, the generality is the religious. And in this case, both they're talking about the efficiency, the lack of research on the vaccines, and that's where the focus is.
Thank you very much.
Thank you. Appreciate it.
Mr. Erickson. You had run out of time. I'll give you an extra minute in rebuttal.
Okay, Your Honor, everything that he's discussing, weighing things of that nature, those are all factual inquiries that are completely inappropriate in Rule 12. I would like to direct you all to the EEOC's brief that in the Keel versus Ringhofer versus Mayo Clinic case, pages 11 through 14, the EEOC goes over exhaustively how the fact that secular reasons intertwine with religious reasons don't invalidate the religious exemption request.
Mr. Erickson, I appreciate you pointing out, that's the Eighth Circuit case that's pending, right?
That's correct.
Okay, can I ask you a procedural question?
Yes.
Okay. Let's suppose that you're correct, that what's been stated here is sufficient, okay, to have lodged a religious objection. In the litigation, wouldn't the next procedural, it would mean that the complaint is adequate, which effectively is incorporating or drawing upon the exemption requests that were submitted. Then the case would proceed to summary judgment, would it not?
That is correct.
Okay. And at summary judgment, it may be the case that the court determines that the plaintiffs made out a prima facie case. And so the way Title VII is working here, it's kind of the focus is then shifting over to the employer, right, to show that the religious exemption cannot be reasonably accommodated without the imposition of an undue burden. Would that become the next relevant inquiry in the litigation?
100%, Your Honor. And as you all know, under Groff v. DeJoy, the standard is significant hardship.
Right. So, for example, I'm making this up, okay? Aspirus could come in and say, for a surgical nurse that works with acutely ill patients, in our medical judgment for the health and safety of both our patients and our employees, we are requiring a vaccine. Okay, and then that's the issue that would get joined at that point, right? I'm not trying to litigate it here in the
100%, Your Honor. And
Okay.
obviously, we pled in our complaint that at the time of the vaccine mandate, the CDC had already found that Delta was the dominant variant, and that with regard to Delta infection, the viral loads for the vaccinated and unvaccinated were identical.
Okay, yeah,
Or
I don't want to get
vaccinated
into it.
were-
I just want to make sure that we understand that once this issue is, if this issue can get resolved, and this is a hard question, this issue can get resolved, the litigation just moves forward on the track that it would in any other civil case, and we just move to the next relevant question, and you all do discovery and hash it out.
100%. And the difficulty, the reason why they cite no circuit court cases, the only circuit court cases that they're citing are in favor of dismissal at the Rule 12 stage, are cases related to the Church of Raw Vegetables, the Church of Marijuana, and a made-up religion. All the cases that cite to Rule 12 dismissals at this stage, those are the cases. These are Christians, Your Honors. These are Christians and Catholics. These are established religions, and and the Eighth Circuit found that the Africa analysis just completely is thrown out when you're dealing with Christians, because it's an established religion, everyone knows. And so then when they plead that their Christian or Catholic faith prohibits vaccination, which happened here. I mean, Ms. Boubet said, I am following my conscience in refusing the COVID vaccine. According to the Catholic Church, I am required to follow my judgment of conscience. That can't be any more clear. And
Right, you're going to have to wrap up. Your time has expired.
thank you, Your Honors.
Thank you.
Obviously, we would request that the district court be reversed.
Thank you. Our thanks to both counsel. The case is taken under advisement. And our final case this morning All right, our final case this morning is United States against Anthony Bailey. Mr. Greenberg.
May it please the court, Jonathan Greenberg, Associate Federal Defender on behalf of the appellant Anthony Bailey. The issue before the court is whether the district judge erred in denying Mr. Bailey's motion to suppress and finding probable cause for his warrantless arrest. That question presents two facets. First, whether the video evidence in this case utterly refuted the officer's testimony at the evidentiary hearing, thereby triggering review under the Scott v. Harris standard review. And second, whether the volume of Bailey's speech alone justified his arrest for disorderly conduct, notwithstanding the Wisconsin Supreme Court's limitations on that statute as applied to speech. I will begin with the first facet, getting to the second as time permits. Ordinarily, an appellate attorney standing before this court arguing credibility is in a very tight spot. This court gives tremendous deference to the trial court's factual findings, and that deference is at its apex when it comes to credibility, and that makes perfect sense. Credibility doesn't turn on just what the witness said, but how it was said, things such as body language, tone, and demeanor, which cannot be captured by the dead tree record. But there is an exception. As video evidence has proliferated, courts are often in the exact same position as the trial court, as the finder of fact, when there is a video record of the events in question. And when that video evidence utterly refutes the witness's testimony, courts are liberated from having to rely on the trial court's factual findings. Now, the Scott v. Harris exception is a narrow one, and it is triggered by unambiguity. When the evidence is not subject to multiple interpretations, it applies, and when reasonable minds can differ, it does not apply. And this court's case law, mostly in the context of Section 1983 excessive force claims and Fourth Amendment motion to suppress claims, really teases that out. In a case where you have a 1 second, a 6-second snippet of video, where there is no audio or it's in black and white, that does not trigger Scott v. Harris. But in a case such as Dockery, where everything is captured on video and you can see what has happened, when that video refutes the witness's testimony, the appellate court can rely on it, and that is what happened here.
Seems to me, Mr. Greenberg, your argument would have more traction if we were attempting to contrast the video portion of the fight versus the description of the fight. However, once the officer runs up to the back of the car and sees the two individuals, from that point forward, it's really just relatively straightforward video, isn't it?
And that question kind of sounds in U.S. v. Bender, a recent decision of this court, which I believe Your Honor authored. And in that case...
The decision of the court.
Yes, a decision of the court, yes, Your Honor. In that case, it was a very classic felon in possession situation. The defendant ran from the police. During the chase, he threw the firearm, and there was a partial video. The video did not capture the toss, but it did capture a bulge and the defendant patting the gun. And the argument on appeal was, well, because the video didn't capture the toss, you know, it was an impossibility. And this court's point was there was actually no problem here because there was no inconsistency. And that's different than this case because the officer testified both at the hearing and in his report, I saw them fall into the snow. And that's just a physical impossibility on this record. Like Dockery, you can see both participants in this altercation at length. You see Mr. Bailey 4 minutes. You see his female companion for at least 1 minute. This court will analyze the video frame by frame. On the one hand, my opinion of the video doesn't matter. As the magistrate judge said, the video is the best evidence. But he reached the same conclusion that I did. There is no snow, wetness, or soil on anybody's clothing. And that matters. These people were wearing bright clothing. Mr. Bailey had a yellow sweater. His female companion was dressed in all white.
Mr. Greenberg, can I ask you a question? Let me put the question hypothetically.
Yes, Your Honor.
Suppose that Officer Variel said, here's what happened. I got a 911 call. It's about 1 in the morning. I show up in the neighborhood. When I got in my car, I heard people arguing. So I did it, ran toward it, all that. And he said, yeah, and I saw them fighting. They were fighting right at the back end of a silver SUV. Okay. And then he goes on to describe what was going on with the fight and how the gun got found and all that. And it turns out that the video shows definitively it's a black SUV. And the sergeant says, you know, I could swear to this day it was silver. I can see in my mind it was silver. He's just dead wrong. Does the whole account, his whole account of what he saw, get thrown out
that fact pattern would not trigger Scott v. Harris because that discrepancy is immaterial and doesn't utterly refute the broader testimony. And the natural pushback is, well, aren't we in the same boat here? Who cares whether or not these people fell into the snow? That has nothing to do with whether or not he saw a physical fight where Mr. Bailey was actively fighting. Because if he was fighting, obviously that's disorderly conduct. And the answer is, this is not a minor point. This is not just gilding the lily. Impeachment in our system usually proceeds by showing minor inconsistencies. You rarely have that Perry Mason moment, because when somebody has proven to be demonstrably wrong, wholly wrong about something small, you can't trust them on the bigger things. When they are not candid on the small things, you cannot credit them on the big things. And in the court's example, a difference in the color of the car doesn't matter. Who cares? But when the officer has been shown to essentially add flavor that is belied by the record, it calls his entire narrative into question. And for that reason, we submit that the doctrine of Scott v. Harris does apply here, and the lower court clearly erred in crediting the officer's testimony. I am approaching the end of my time, but to briefly approach the speech issue, even if I've convinced the court on this issue, there is still the matter of the noise. Under 947.01, disorderly conduct includes boisterous and unreasonably loud conduct. And there was a loud argument here. So the natural response is, well, they were loud, therefore couldn't the officer have arrested him? And courts are naturally hesitant to vest such power in the police to arrest anybody just because they are subjectively loud. The Wisconsin Supreme Court has placed very firm guardrails on this statute. It does not reach First Amendment protected conduct. And even for the non-speech elements of conduct like volume, it has to be objectively unreasonable. And this record does not support that finding. As the Wisconsin Court of Appeals held in Olston.
But for probable cause determinations, we don't require officers in the field to identify possible First Amendment defenses to a disorderly conduct prosecution before they make an arrest. And if that's your whole challenge, you're, number one, misreading the Douglas D case dramatically, because that was all about a content-based issue, not because it was a class project, a creative writing project in a school where a student wrote an essay about cutting off the teacher's head. And so that it's entirely off topic, but even setting that aside, to the extent that there's various First Amendment defenses to certain disorderly conduct prosecutions, we don't require officers in the field making probable cause determinations in arrest situations when they're dealing with loud, boisterous arguments to sort of parse the nuances of First Amendment law and whether there's going to be a First Amendment defense to this disorderly conduct prosecution. That's just not required.
I understand the court's point, but the First Amendment aside, there still has to be showing that this was objectively unreasonably loud, as the Supreme Court of Wisconsin.
Not for probable cause. Not for probable cause. We don't have to have a videotape at a certain decibel level to make that determination. And the officer's testimony alone was enough, and the district court credited it.
It's not sufficiency. They, of course, don't have to prove every element of the offense, but there still has to be probable cause that it was objectively unreasonably loud. And here, where you have a fight that's only audible from 3 houses away, that doesn't suffice. Unless the court has any further questions, I will reserve the remainder of my time. Thank you.
Thank you. Ms. Kraus.
May it please the court, good morning. Taylor Kraus for the United States. This appeal turns on a narrow question. Do a few seconds of video footage discredit an officer's testimony that he heard and saw Bailey and a woman fighting outside near 1 a.m. in a residential neighborhood utterly discredit his testimony?
Does the fact that there were previous noise complaints from this party, A, does the officer know that, and B, does that affect our analysis?
Your Honor, the record demonstrates that the officer did know there were previous noise complaints, but I submit that does not affect the analysis here, because as soon as the officer approaches the scene, what matters is the totality of the existing circumstances. And the video, in every way that it can, corroborates the officer's testimony that he first heard shouting in the distance. Within seconds after exiting the squad car, There is shouting audible on the videotape. He then breaks into a run and contemporaneously advises dispatch that a fight is in progress. Those are the kinds of present sense impressions and contemporaneous observations that are afforded a high amount of trustworthiness under our rules of evidence. And as the officer begins to run towards the house, the camera is jostling so much that you might need a tramadol, so the fight is not picked up. But what is picked up is his commands to Mr. Bailey and the woman to knock it off, get on the ground. He then grabs Mr. Bailey. At that point, it is true that Mr. Bailey and the woman are visible on this video, but the video shows it is for a brief few seconds, and not even their entire bodies are visible on this video. Attorney Greenberg included photographs in his brief, and you can see that's it. Not their entire fronts, not their entire backs, and in fact, the woman was wearing all white. I submit it might be difficult to see white snow on white pants. You also see that the sidewalks and street and driveway of this neighborhood are relatively clear of snow. After Bailey is detained by the officer continues to make these contemporaneous observations that he's detained the two people involved in the fight, and then he walks Mr. Bailey to a squad car and tells him, I saw you fighting. I saw you grab her, and then I saw her hit you. All of this taken together credits this officer's testimony. The standard here is under Scott versus Harris, United States Supreme Court standard, that the video must utterly discredit the officer's testimony. Here, we don't even get to discredit because the video completely corroborates his testimony. This court most recently addressed video evidence and witness testimony last month in United States versus Bender. There, this court said that a video evidence needs to make testimony impossible under the laws of nature in order for a court to reject witness testimony. Here, there is nothing about the video that renders the officer's testimony that he thought he saw someone fall to the snow physically impossible. I want to turn to Attorney Greenberg's second argument on this appeal. And in order to get here, this court must first reject the district court's credibility determination, which, as this court is well aware, is afforded the most deference. So in order to get away from probable cause, which Attorney Greenberg concedes, probable cause exists here if you exclude the unreasonably loud noise based on the boisterous, abusive, fighting, violent conduct that the officer observed in the street. So the only way for the court to reject probable cause is to undercut the district court's credibility determination. But again, addressing what constitutes unreasonably loud conduct, there is no test that Attorney Greenberg has advanced here, that it needs to be conduct that is akin to shouting political speech over a megaphone at 2 a.m. That is an example used by the Supreme Court of Wisconsin, and an example that demonstrates how this is a fact-intensive analysis that's done under the totality of the circumstances. So there is no upper threshold that is posited again and again in the defense briefing. Here, it is unquestionable that the noise was heard when the officer stepped out of the squad car. It got louder as he approached and is heard even over his panting and the sounds of his footsteps. And there's no question here that yelling between two people after midnight, heard at least half a block away in the middle of a residential neighborhood, is the kind of unreasonably loud conduct the Wisconsin disorderly conduct statute contemplates. With that, Your Honors, if there are no additional questions, I ask that you affirm because the district court did not err in finding the officer reliable and credible.
Thank you. Mr. Greenberg.
Thank you. Just 3 quick points in rebuttal. As to Judge Brennan's question, I don't believe the prior noise complaints are relevant to the analysis. Probable cause is always particularized to the individual. There is no indicia in the record that the prior complaints related to Bailey, so I don't think that adds anything to the analysis. As to the government's point that the video in question is a matter of seconds, again, I respectfully disagree with that. The court will see the video for itself. But you can see both Bailey and his companion for ample time, enough time to see their clothing. And finally, as to the officer's post-arrest statements, it would be one thing if those were candid assertions, but officers are well aware that anything they say in a body camera is picked up. And to me, there's not much difference between what he says post-incident and his in-court testimony. With that, I respectfully ask the court to reverse. Thank you.
Thank you. Our thanks to both counsel. The case is taken under advisement, and that concludes our calendar for today. The court is in recess. And again, we thank the University of Wisconsin Law School for hosting us this morning.
All rise.